Hey everybody, this is Attorney Kenneth Stevens from the law firm Stevens PLLC, and today what I want to talk to you all about is litigation. I'm hoping to eliminate some of the questions you all have, some of the stigma associated with litigation. Maybe some of you have some disputes that you're kind of on the fence about, and you're like, I don't know if I want to go into that. I've never dealt with it before. I'm hoping to kind of answer some questions and maybe help you make an informed decision. So first of all, I want to talk to you about what the litigation process looks like. First, you have case initiation, which is basically the drafting of the petition or the drafting and responding to the petition with an answer, right? So that's not a overly burdensome process. You really just kind of investigate the claims. You look into your defenses if you're on the defense side, and you draft a document, and that document's filed with the court, and it's either the petition where you're making the allegations or it's the response to the allegations. It's not a crazy process. It's not that expensive. The next part of the litigation process is the discovery process, and during this process there's a lot of back and forth between attorneys using various documentation and various methods and strategies. This part of the litigation process is normally the most expensive part of the litigation process. Between this and the actual trial is where most of the money is spent. Again, documents are being sent back and forth. Time is being spent objecting to these various documents. Sometimes parties have to go to court because one party doesn't want to give up documents. So it can get expensive. This is also the time where experts are evaluated and retained. And this is also the part of the process where depositions take place. So court reporters have to be paid, and attorneys' time for depositions, travel, all this different stuff kind of comes into play during this discovery process. So this typically, again, is the most expensive part of the litigation. So if you look at your case and you're like, well, there's not really that many documents at all. I mean, there's just the contract and maybe a couple of emails, then maybe your case won't be that expensive to litigate. Also, if there's not a whole lot of witnesses, if you're thinking to yourself, well, really it's just me and the owner, or maybe it's just me, the owner, and one other party, then maybe it's not that expensive to go through this process, because the discovery process is where most of the money is spent. So if you cut down on this part of the process, then you can really cut down on a lot of the litigation costs. So after discovery, then you have the settlement phase. Normally it's through some kind of form of mediation, or even sometimes it's done informally. The parties can get together, discuss the strengths and weaknesses of the case, and reach a resolution. So most cases actually settle here. About 90+% of all litigation cases settle during this settlement phase after everybody has had a opportunity to evaluate the strengths and weaknesses of their case as well as the opposing party's case. And so the good news is, if your case wasn't very discovery intensive, you didn't spend a lot of money on the initiation phase, then by the time you get to the settlement phase, you haven't spent too much money, and you can make a great business decision with regard to how to resolve this case. You can kind of weigh the numbers and then make an informed decision. So up until this point, you got to look at it. I mean, litigation doesn't have to be super expensive unless you have a really, really labor-intensive case. Now, granted, in 2013, a study was done, and it did show that on average, from case initiation all the way to post-trial, 367 hours was actually the average amount of hours in billable time that lawyers and their staff spent on cases. However, this is everything ranging from major multi-party commercial contract litigation down to just single-party litigation. So obviously, it could be a lot less time if your case is a lot less complex. And again, this 367 is from beginning all the way to post-trial. Most cases settle way before this 367 hours is ever hit. However, what I do have to stress to you all is, if you are going to go all the way to trial, right, and you do have a sort of complex case, what you have to ask yourself is, do you want your attorney spending the average amount of time on the case, which means they'd be just as prepared as everybody else? Do you want them spending more time, meaning they should probably be more prepared than the other side? Or do you want them to save you money and spend less time, which means they may be less prepared? Now, granted, some attorneys are more efficient than others. So, they may be able to spend 320 hours and achieve the same result. But do you really want them to go to trial having only spent 100 hours if the other side has put in the time and spent 350, 360 hours? I don't know. It's just something that you have to look at and decide. Now, the next part of the process is the pretrial process, and that process can get a little expensive because you haven't settled the case, you've gone to discovery, which means you're kind of invested in the case, and now you're spending time drafting motions, researching, and trying to keep certain things out at trial, maybe get some of the claims dismissed early. This is what we call motion practice and pretrial practice. Then the sometimes most expensive, sometimes second most expensive after discovery is the actual trial. Attorneys spend a lot of time, a lot of labor actually litigating the case, whether it means they're in trial or after they get done with the trial for the day, they're preparing for the next day, prepping witnesses. All those different things make it very expensive to go to trial. This is why most of those cases, the 90-something% settle before this step, because it's a very, very expensive part of the litigation process. But again, if you look at your case and I don't have that many witnesses, I don't have that much discovery, the trial should maybe only take a day, maybe even a half a day, then it doesn't have to be that expensive. So again, we've talked about case initiation, we've talked about discovery, we've talked about the settlement phase, we've talked about pretrial, and we've talked about trial. If you look at your case and you think about everything I just said and you're like, you know what, it doesn't seem like that complicated of an issue, there's not a whole lot that we have to go through to kind of get everything fleshed out, your case may be a great case for litigation because it may not be that expensive to litigate. So anyway, I hope that this is helpful. I hope I helped answer some questions. You all share it. Hopefully I eliminated some stigmas, and happy building.